All right, so thank you everyone for joining us. My name is Jeff Oberl. I am the Training and Development Manager for CAD and Community Management. I want to thank you for taking time out of your night to learn a little bit more about this change to Arizona law and how that's going to impact all homeowners associations and how you run your board meetings and prepare for them. We're joined tonight by John Hulk and Kelly Oettinger from Hulk, Oettinger, and Brown. And I'm sorry, Kelly, I know I butchered it. I practiced with John earlier.
No, you're on. You got it.
And I'll let them introduce themselves a little bit more once we turn the meeting over to them. Just a couple ground rules for tonight. As you will notice, everybody is on mute, but you do have access to the chat. And I'm sure you're going to have questions along the way, so please utilize the chat. We'll ask them along the way, and we'll have some time at the end of the evening as well. So without further ado, I'm going to turn the meeting over and share my screen. And John Kelly, it's all yours.
Awesome. Thank you so much, Jeff. It's a pleasure to meet with all of you. There's been a lot of discussion about this new case law that came out, so we're happy to have the opportunity to walk through some of those rulings and some of those issues and answer any questions that you guys might have as well along the way. By way of just a brief introduction, my name is John Hawk. I'm one of the partners here with Hawk, Oettinger, and Brown. We do all the litigation in our firm. I've been practicing law for about 11 years. Our firm has been around since 2005. We've been practicing for over 20 years here. We do exclusively HOA law and do everything from collections, general counsel questions, and working through issues like new case law that changes how all of your open and executive sessions are to be conducted at the drop of a hat. So looking forward to getting all of these resolved. And I've also here with my partner, Kelly Oettinger.
Yes. Hi. Yeah, I'm Kelly Oettinger. I handle most of the general counsel questions in our firm, so you can feel free to reach out at any time with any legal questions you have. And we'll go over the case like John said. We'll try to keep an eye on the chat and feel free to ask questions throughout. I know this case sounds like a lot, but I think once we all get it down, it'll be smooth sailing in a few weeks once everyone gets the hang of the changes.
Definitely.
But yeah, some background. So basically, this case sort of took us by surprise a couple of weeks ago, and it reiterated and reinforced the public policy that's already included in the statute. So basically what the court is saying, we're not making new law, we're just interpreting this as always having been the law, even though no association has ever practiced this way in Arizona, at least. The good news is this is already the law in several other cases. So, I mean, states. So we already know other states, HOAs are already doing it this way. So it's not going to be as big of a problem as we originally thought. And there's also a law pending in the legislature this session that is probably going to pass that would have made this a law in October. It just happened a lot sooner than we thought. So we didn't have that 6 months to prepare for it. We've only had a week to sort of digest this and have it take effect immediately.
Yeah, so I guess a bit of background on the case, just for how we got here. The case was filed by a homeowner who was also an attorney, of course, and had an issue with how the board was running their meetings. This attorney filed a lawsuit because the board of directors was making decisions and taking votes on action items in their executive session. Some of those items included a $917,000 budget item. They also approved the manager to have spending authority up to $7,000. And these were all passed in that executive session. The root cause of the complaints and the issue was that the homeowners didn't have this opportunity to hear what was going on. And one of the key points of the open meeting laws is that before there's a vote taken, there's an opportunity for the members of the association to speak, not to ask questions or cross-examine the board, but just that chance to speak and have their voices heard. So that's kind of the background on this case. And when the Court of Appeals came in with their decision, it raised a number of different issues. And we've got this PDF here. There's a copy of it available for anyone that wants it afterwards. We'll just kind of walk through those each and discuss the implications of this ruling.
Yeah, so the main point of the case is that items may be considered and deliberated on in executive session, but the actual voting and decision making cannot be done in executive session. So there are 5 topics that as a board you're permitted to consider in executive session. You're allowed to discuss that, deliberate back and forth, kind of come to the consensus of how you're going to vote, but you have to then actually do the voting in an executive session. I mean, in an open session, sorry. So the problem arises because the 5 topics you can discuss in executive session are attorney-client advice, pending and contemplated litigation, financial and private information about a homeowner. So all of that, the actual details need to still be kept confidential because you can't be waiving the attorney-client privilege. You can't be disclosing personal or financial information related to a homeowner. So while the voting does have to happen in open session, we still need that the actual motion to still be kept vague enough so that the owners don't have all the details. So it's somewhat of a silly decision because you'll be discussing the details of, say, whether to settle a case you're involved in litigation on. You're discussing your advice from your attorney in the executive session. You're discussing the amounts and all the details in executive, but then you have to go to open and say, motion to settle the case as discussed in executive. The members have no idea what the details are. They just have a right to know that you're making that vote and decision. They also, like John said, it's clear from this decision that owners have a right to speak on a motion before the board votes. That's really impractical for a lot of these executive motions because they don't know the details. So it's important to remember they have a right to comment on and speak on. They don't have a right to demand answers, cross-examine the board, question you. So what we anticipate coming up is, you're discussing, maybe an owner came to you and asked what if you would waive their fines. You have that discussion in executive, but then in open, you have to vote on whether to waive the fines or not. So as a board, if you vote to waive the fines, we picture an owner say, what do you mean? You didn't waive my fines, and demanding answers like that. So it's just important to remember that's not the time for them to ask you questions. You can just thank them for their comments and move on. The statute says a reasonable number of members have a right to speak on the motion for a reasonable amount of time. That doesn't mean they get 10 minutes to speak. That doesn't mean you have to call on everyone in the room. That just means maybe for a minute or two, they get to make a comment and you can thank them and move on. And I see a question. So will we need to do the general meeting, then the executive, then back to the open? So you could. It's probably most practical if you just do the executive first, then go into open. Instead of going open, closed, open. You could do it that way. But it's a little bit impractical because you'll have to have the membership sign off if you're in Zoom or leave the room if you're in person, then come back. So it's probably simplest to just do executive, then open, and then have the spot on your open agenda for the executive items that need voting.
Good question.
Yes.
One of the other items that we touched on in this decision is this idea that when you're moving from these decisions and the homeowners have the ability to have their opinions heard, a lot of boards have done decisions between meetings by unanimous written consents on email, where there'll be some motion to approve something or some decision that's being made. And just for speed and efficiency, boards are doing this by unanimous written consents. Our firm has for a long time advised not doing that. And this case that came out in Lund Springs reiterates that. The issue that the court has is that if you guys are taking these email votes with unanimous written consents, there's no opportunity for the homeowners to be heard. And if you guys do those and then ratify it at a future meeting, the issue still remains that the homeowners didn't have a right to speak before that vote took place. So this can be really frustrating for a lot of boards, because if you're forced to make those decisions every month, or if you're in an association that meetings, it slows things down even more. There's a lot of other implications of that, but as we move through these, we have a couple of ways to speed up some of those decisions and also keep things timely for the board. So, Jeff, if you want to scroll down just a little bit to that next section, we can touch on some of these next items.
Yeah, and just add to that, a meeting can be held at any time with 48 hours notice. It doesn't matter when or how. It can be held Zoom, speakerphone, in person, whatever works best for you as a board. The only time a decision can be made by email, and it does not need to be unanimous consent, it's just a majority of the board, is in the case of an emergency that genuinely cannot wait 48 hours. In that case, you can vote by email, and then at the next regular meeting, the minutes must be read and the reason for the emergency must be stated. So that's something like something life, flood, some sort of fire or an emergency, something really that cannot wait. Let me see. Another question. Do we need to share names of individuals that in executive session, the board agreed to waive fines or fees in the general session? So no, and we advise against that. I think most of the communities we work with are starting to use some sort of identifier, maybe the internal account number that your management company uses, something that you can keep track of what you're talking about, but that the owners don't know which lot you're referring to, or the specific details of their accounts. Another part of the case was that Sunland Springs, the association, the president was setting the agenda, which the court ruled would have been fine if the board had voted at an open meeting to give the president that authority. They hadn't, so the court ruled that they were in violation of the open meeting laws. So as boards, you can formally delegate certain authorities to specific board members or your manager to act between meetings. So something like that might be having a resolution that delegates the president and the manager to set the agenda before your next meeting. Or something like amending your enforcement policy to say that after a certain number of letters, the president has the authority to send it to the attorney's office for an enforcement letter, or authorizing emergency repairs up to a limited dollar amount. Now, again, in the case, the court decided 9,000 was way too high, or 7,000 was too high. So it has to be something more reasonable. I think a lot of communities will do somewhere around 1,500. Probably 5,000 might be too much, because if it's that high of an amount, you can just call a meeting within 48 hours to make that decision. And another would be making sure you have a collections policy that clearly states what happens to account at specific thresholds, and make sure all of these policies and resolutions are adopted at open meetings, so membership is aware of the policies in place and what's going to happen when they go to collections. That way you don't have to meet every time an account meets a certain threshold. So we've discussed as a firm that, a lot of associations will probably be a lot more policy and resolution driven.
So there was another question here for
in my association, I'm the only member currently, so how would I need to handle this? Wow. That is difficult. Presumably you're the only board member because no one else is remotely interested. So I'm assuming even if you have meetings, no one's attending. So in that case, and again, there's always an owner in the association that is litigious and will complain. In this case, your response would generally be, well, join the board then. Help me out if you're going to complain about me making decisions by myself. Really, all you can do is send out an email once a month begging for board members to join you and help you make these decisions. And yes, I think Jeff can send out a copy to anyone, or you can reach out to us and we can send you this PDF as well.
Yeah, I'll be happy to send that out to anyone that wants it. I have a list of everyone that's in attendance tonight, so we'll make sure we get that out to everybody.
Thanks, Jeff.
Yeah. Does the voting by email only apply to individual homeowners, or does it apply to all expenses such as landscaping and maintenance repairs? So there should be no voting by email. The only time you can vote by email under the open meeting laws and this statute or this case law is in the case of an emergency that cannot wait 48 hours. Every other decision needs to be made at an open board meeting. All decisions are made at open board meetings, unless you have a policy or resolution in place that delegates the authority. So that's why we're talking about you have a enforcement policy or a collections policy that has very clear steps that outline things. That way you don't have to meet every time someone's 2 months late in their assessments. You already know what's going to happen because you've adopted that policy at an open meeting.
And there was one question before we move on that kind of got lost in the chat. There was they missed the information about the president setting the agenda. If you could recap that again real quick.
Sure. So in the case, one of the plaintiff's complaints was that the president was setting the agenda for the meeting, for every meeting, without the authority of the rest of the board. So the court said that would have been okay if at an open meeting, the board had voted to delegate that authority to the president, but they never did. So it's okay to have the president work with the manager to set the agenda as long as you vote at an open meeting to give that authority to the president so that the membership is aware that that's how it works. And there's minutes to that effect showing that decision was made, or you have a resolution you can point to that was adopted at an open meeting.
So if you guys at a board are doing a meeting, you'll have your open session meeting. Someone will make the motion to say, I make the motion that the board president be delegated the authority to, approve the agenda, get a second in that open session. The board will make its motion, and as long as that passes, then it's okay to continue with that practice. So more of a procedural step, but that would be the easiest way to address that.
And I see one more question. Did I understand correctly that if an emergency vote is taken, it must be itemized on the next open meeting agenda and explained? So yes, the emergency meeting statute allows you to have an emergency meeting without the notice to the membership, and it can be done by email. But under the open meeting laws, at the next regularly scheduled open meeting, the reason for the emergency must be stated and the minutes must be read into the meeting for the record. So if you voted by email, then the emails constitute the minutes. Or if you had a quick meeting in person under the emergency, then you would just read the minutes at the next regular meeting. Okay. That's it for questions for now. So let's see. So like we discussed, there are 5 topics that you may discuss and consider in executive session. That's attorney legal advice, pending or contemplated litigation, financial information related to an employee, employee performance or complaints, or an owner violation or fine appeals. And there is an exception to that one because the statute allows an owner to request that their hearing be held in an open session instead. If a topic does not fall into one of those 5 categories, it must be considered in an open session. And no matter what, all voting is done in an open session.
Ed knew what topic we're going to talk about next because he's talking about the ARC committee approvals.
Yeah. So I do see we missed, okay. So would that be the same case for me as a single board member? Do I need to have our community manager and I state in the meeting minutes that I have full? Yeah, that would be a good idea. And like I said, it's very unlikely anyone will complain, because usually when there's only one board member, that just means the whole community is apathetic and they really don't care what you're doing. But yes, it would be a good idea to have that in meeting minutes, that you, I guess, have delegated to yourself and the manager to run the affairs of the community. And then I would just suggest once a month sending out a call for a volunteer, just to show you're trying to get people involved if anyone ever complains.
Yeah, and when you make that, would it be appropriate to say that you're still delegating it to the president, which of course is that sole
Right.
board member? So in the
Yes.
future, it would be okay.
If the ARC committee approves an ARC request, go ahead to the homeowner can't be given until it's approved in an open meeting. And are members of the committees of the board restricted? Okay, so we'll kind of hopefully answer both of these questions in this next section, but it's a little confusing. So these open meeting laws, in this case, apply to regularly scheduled committee meetings. So if you have a committee that meets once a month, once every other month on a regular basis, you have to follow all of this. If you have a committee, like say your architectural committee only makes a decision when a request comes in on an as needed basis, then these open meeting laws don't apply, except a complication arises if your board is the committee or a quorum of the board is on the committee, then you are subject to all of these laws. So let's say you have a committee, you have your art committee, you have one board member and then 4 other members from the wider membership. That's not a quorum of the board. That's not the board meeting. And you only meet when a request comes in, then you don't have to really follow any of this. If you have a quorum of the board on the committee, then you do. And I know that's kind of hard to wrap your brains around. It's confusing to say. So hopefully I feel free to ask any questions clarifying that.
Yeah, it's a lawyer speak that the statute requires in the open meeting laws, because corporations laws is so fun to work with sometimes. But I guess as an example, if you have a 5-member board, then if that 5-member board has 2 or less members of the board on the architectural committee, you have to have at least 1. But if you have 1 or 2 on the architectural committee and they don't meet on a regular basis, they just meet whenever those applications from the ARC come in, then they don't have to follow these open meeting laws. They don't have to make these votes during an open session. You guys can just review those and pass them outside of this whole scope. So if you have an architectural committee that is composed of the board, it might be beneficial to create a committee and delegate that authority to a committee so they can review and approve these, because otherwise if the board's doing it, you're going to review those architectural requests in an executive session and make a decision, and then in the open session have that identifying.
Yeah.
Go ahead.
So sorry. They're really, unless it falls into one of those 5 specific categories, architectural requests can't really be deliberated in executive.
That's true. Yeah. And then when your decision on those architectural requests are being made, it is going to be discussed in the open session. You're going to have that anonymous number assigned to the accounts, and it makes things a little bit harder to do. So consider those committees.
Yeah, the real issue with this is a lot of your CCNRs have that language that says a request is automatically approved if you don't make a decision within 30 days. So if your board is the committee, then you're going to be meeting a lot more as these requests comes in if you only have 30 days to approve them. But yeah, so they do have to be, if there is a meeting, it's open to everyone. There's nothing privileged about the request, and none of it is redacted or anything with respect to architectural requests. But you don't have to have a meeting if it's not the board, if it's just a committee and they're not doing it on a regular basis. And with respect to this question, if members of the committee are restricted in their communications with one another, and again, it sort of depends on the composition of the committee. So if you have a quorum of the board on the committee, then yes, you're restricted. You can't be emailing back and forth. But if it's a committee of one board member and 4 other people from the membership, then it's not a quorum of the board. It's not a meeting. You can freely communicate outside of meetings. Meeting scheduling. So we sort of already went over this. Consider the executive first on moving to open session. And this actually might, we have heard from some boards, this might be helpful in keeping boards to a schedule and keeping the executive session from running long. Because if you've noticed a meeting at, say, 6:30 for open, you'll have to try to keep to that as much as possible and keep the executive session within that timeline.
Yeah, I've heard from a few boards that are starting to plan for this type of meeting schedule, and they're starting to start their executive session maybe a half an hour earlier than what they would normally do for their board meeting. So all the homeowners are still on the same schedule. So let's say you've always had your board meeting at 6 o'clock. Well, you as a board can do your executive at 5:30 and keep your homeowners on that same 6 o'clock schedule. So something to keep in mind when you're planning for that. All right, so the agendas. I know there was a lot of confusion about the agendas. As everyone knows, we have to provide the board meeting agenda, but what does this change in law have to do with the executive session?
Right. So members, the ruling also stated that the members are now entitled to the executive agenda. So previously, we had to notify the owners that you were having an executive session, and we also had to identify the section of the statute that authorized that executive session. So one of those 5 categories, you would just reference the statute category and be done with it on the notice. But that wasn't enough. And now they're entitled to the executive agenda, and it has to reasonably inform the owners of what's being discussed. So just referencing the statute is not enough. We have to be more specific, but again, not too specific to let the owners know or waive attorney-client privilege. So do we have I'm trouble reading that. So it must provide owners enough information. Thank you. So you can do account numbers to identify homeowners and just say, you might have a category for enforcement or violations and just list account numbers. You don't have to say what the violation is, but you can put the number of violations and let the owners know that you're discussing a violation. If you have ongoing litigation, you can put discussion of ongoing litigation. If you're unhappy with your landscaper and you're discussing that in executive session, it would fall under discussion of an employee performance. You would put discussion of landscaper's performance, something like that. Not too specific, but also a little bit more information than they've been previously provided. One note is they now are entitled to the agenda. They're still not entitled to the minutes. So your minutes will be, there really won't be a record of what you did because all the decisions and actions are actually taken in open session, but it'll say something, like call to order, discussion of violations, discussion of litigation. So they'll be really, really simple going forward.
Ed's got a question in the chat here asking, what's the penalty for not complying with any of these new regulations, but doing things as are presently done? It's a good question, and it's kind of where this whole Sunland case came from in a way. There was a board that wasn't technically following these open meeting laws. A homeowner was upset about it. They filed a lawsuit, Both sides incurred tens of thousands of dollars in legal fees, and the homeowner in this case prevailed because the HOA wasn't complying with these open meeting laws. So the HOA is liable for all of that homeowner's legal fees, and they're going to have to go back and correct some of these issues that were existing. Another issue that we see, or that we've begun to see, is there's a number of different law firms that represent homeowners specifically. And if we're doing a collections case for assessments, assessments are black and white, right? If you don't pay your assessments, you lose. If you have a check copy, it's really your only defense. So the way a lot of these other law firms are trying to manufacture defenses is including an initial demand letter with their response to litigation with a records request saying, give me all of your meeting minutes, give me all of these documents of the association. And they start to pick apart these items. And if they can find that there were things that were done improperly in the board meetings, things that were passed outside of an open session, anything they can find, those law firms are going to be looking for those reasons to find a reason to do a counterclaim or make other allegations against the association in order to settle those cases. So it's a bit difficult to navigate this, I understand. I think that the PDF will help, but that's some of those implications. Rules aren't followed.
And I see another question. Did you say that the actual minutes of executive minutes have to withhold detail? So not exactly. The membership is not entitled to the executive minutes. It's just that there won't be much detail because minutes are a record of actions taken, and you will no longer be taking action at an executive session. You'll just be having the discussion and consideration. So the minutes won't have much to them anymore because they're not meant to be a transcript of what was said. So it'll just be different categories of what you discussed, and they won't really have a lot of detail to them.
Another question that came in says, does a master association fall under this ruling if it's not considered an HOA?
So that one's hard to answer without looking at it. I would say most likely, but I would have your attorney or us take a look specifically at that one. But I would err on the side of yes, it does.
I think some of this you've talked about already, but maybe talking a little bit more about utilizing policies to reduce delays, as it says here, but to keep things moving forward outside of meetings. I think you used a reference to violation. If they've received so many violation notices, you give the president authority to proceed to the attorney's office. Could that be used also for collections as well? And what would you recommend there?
Yeah, definitely. The way to one of the biggest takeaways, I think, from this case is finding ways to automate systems within your association. For some of the clients that we represent, they still pass things in their meetings, whether they send something to collections. We want to review things before they go to foreclosure. We want to review all these little items, and they still can. It's going to make the meetings longer. It's also going to require those votes in an open session. And you're going to be talking about individual homeowners who are in those situations, discussed anonymously by a number of some kind, of course, but still. The alternative is by either relying on your collections policy or revising an older one that you have. So if you have a collections policy that says, after you miss your second or third assessment, we're sending a final demand letter, and then it immediately goes to the law firm for collections, that completely removes board decisions from that. It's just automated. Same idea goes with fines. If you have a fines policy that you adopt at an open session, and in that open session, it appoints the president with the authority to send cases to the attorney for enforcement matters, the board can do that as well. And that's going to make it easier to just start to move these files into compliance, get these action items moving, and it avoids having those conversations where you're kind of dancing around the idea of these individual homeowners who have these problems and making these votes, giving the entire community an opportunity to have their voices heard, and those. So it's a great way to just automate things. Relying on your policies can be really helpful, and there's going to be a lot of benefit to that.
Great. And Mark, yes, you kind of stole my speech I was going to give at the end. You had asked if the community managers are going to have updates and be able to assist with the boards moving forward. And yes, as you can imagine, just like you all are learning about this, all these changes, as are we. We've had a few training sessions here, and we will be guiding you through a lot of this. Some suggested actions to take, like we talked about, making sure it's clear that the president sets the agenda if that's what the board would like to do. Maybe modifying your architectural committees to give you some freedom to discuss matters. If you have a quorum of the board on your committee currently, maybe we can reduce that and, kind of open up your communication and approval power there. So yes, more to come specifically to each board from your manager on suggestions for your associations.
Definitely. And I mean, we're kind of going over this in broad strokes just to kind of give everyone the general idea of how these all work. Of course, every community is going to have its own individual issues. Speak with your own attorney about those. Our firm handles it a little bit differently. We have a general counsel plan that's $50 a month. It's unlimited questions for one board member and your manager. So if you do have questions about this law, your documents, anything else, it's all included at no additional cost. So for anyone that's already with us, ask us anytime, or if anyone's paying too much for those fees, then we're happy to help as well. Regardless, we do have this PDF. It's going to summarize a lot of those issues, and that can help spark that conversation with our legal counsel as well.
I see a question. If we go into executive session at the end of our regular meeting, do we adjourn the regular meeting and begin a new executive meeting, or pause the original and return to it after the executive? So you'll need an agenda for each, the open and the executive. So I think most communities will do executive, then open. So you'll need one agenda for each part. If you do open, closed, open, and that's planned, you'll have 3 agendas really, or it'll be part 2 of the open. But it would be, I guess, a planned adjournment back into open. For the president to set agenda items, can there be email communications between board members? So the violation of open meeting laws occurs anytime a quorum of the board is emailing back and forth about association business. So that's when you're deliberating, considering open matters. So if the president sends out an email and says, does anyone have anything to add to the agenda? And you all just reply to your president or manager and say, I'd like to discuss this, and you're not going back and forth on that actual substance of the matter, then that's fine. But when you start getting into the substance of the issue and getting back and forth when the quorum's there, that's where you'll get into trouble. But logistical items like the meeting date, setting the agenda, that's not really an issue because you're not deliberating on association business. You're preparing to discuss it at the meeting.
I know they touched on it a little bit earlier, but handling those homeowner-specific matters, we are making the recommendation that we use the CADN-specific account numbers. So that will become kind of second nature for you. And that information will be shared with you in your executive session. So when you go back into your open session, you can refer to any of the homeowners by their account number in the motions to keep their privacy there. So that is how we're going to move forward for our boards.
And another takeaway we've gotten from some of our clients is that it might be a good idea when you do go into open session, right at the start of the meeting, put those executive matters and vote on them right there. So it's fresh in your mind and you remember, because it's going to not be very specific on the agenda. You might later on in the meeting, an hour later, you might not remember what account you were referring to or what the exact issue was. But if you go into open, ready to vote, you'll be prepared to make all the decisions you just discussed in your executive session.
No, that's an excellent point. And boards, you'll see a modified agenda, which will outline basically exactly that. It's going to call the meeting to order, and you're going to address your executive session matters first. And then everything after that's going to look like normal. You're going to approve your minutes and move into your reports just as you have before.
After all those homeowners have their opportunity to speak.
Yes.
And John, I love the way you had said that, and that's something that we try to work with our managers and boards about too. Is it's a time for them to address the board, right? To speak, not to, like you said, interrogate or question. They provide their input, you thank them, and then you move on with your vote. I
Right,
think
and
that's very
it can be very hard not to respond to someone, so it does take some, especially when someone's getting a little fiery at you, but it's really important just to say thank you and move on. It's not their time, it's a board meeting, it's for you to conduct your business, it's not a membership meeting, it's not for them. They have a right to be aware of the decisions you're making, but the meeting is for you as a board.
Yeah, and if any of you have been on a meeting with me, I have a very loud 30-second timer or 1-minute timer, and we are very
That's
strict
excellent.
by it. So
Good
thank
for you,
you.
Jeff. That's
Move
perfect.
on
Yeah, I
to
like
the
that a lot. Let's see. So let's see, make sure okay. Does any of this impact the working sessions of the board scheduled between board meetings that are open to homeowner participation? Yes. So the statute is very clear that workshops are subject to the open meeting laws. So if your workshop includes a quorum of the board, then yes, you have to follow all of this. If it's so, let's say you have a 5-member board and 2 of you are getting together to discuss informally the budget and work on that in between meetings. That's not a board meeting because it's not a quorum. But if you have a workshop with a quorum of the board, you have to make sure to follow all these rules.
So to that, Kelly, I want to add, and correct me if I'm wrong, if we have a work session but there's no decisions being made or votes taken, homeowners can be there to observe, but there's really no chance for them to participate if you don't ask them directly, correct?
Right, because the statute only specifically says they have a right to comment after the board deliberates, but before the board votes. So if there's no motion on the table, they really don't have a statutory right to speak. They just have a right to observe.
So oftentimes in boards, you may have seen this, we'll state right in that meeting notice for a work session that no decisions will be made, no votes will be taken, so they can be there to observe, but there's really no input period.
We have another question. If the board has dealt with a homeowner complaints in executive session, then report and vote in open meeting with the homeowner present, how will that work? Yeah, so logistically, they have so generally the way it would work is you schedule the hearing for an executive session. You announce the violation, you give the homeowner maybe 5 to 10 minutes to submit their appeal, whatever they want the board to consider. You would dismiss them from the executive session, deliberate on as a board, then go into open and do the vote. So the owner could be present during that vote and they will know exactly who you're referring to, but the rest of the membership won't.
That's a good question here. What's a reasonable amount or equation to determine the HOA president's emergency spending approval amount?
Yeah, unfortunately, there's no set equation. John and I always like to joke, the ultimate person who decides what reasonable is the judge once you get sued. Unfortunately. So we already know that, and I think this Sunland Springs was a rather large community, and 7,000 is too much. We have that line in the sand. So somewhere below that, and it really should be, just for minor, I would say, unless it's an emergency, something that's so minor, you just need to like replace light bulbs, something like that, pool furniture. Not something you would normally go out and get 3 bids for because it's a larger dollar amount job. I think most communities around 1,500 is probably reasonable. I have one that's trying to do 5,000 and I think that might be too high.
Yeah, and those higher dollar amounts, you're kind of getting a little bit more risky, right? Because like we said, it's reasonable, and depending on your community and depending on those issues, we could argue it's reasonable, but a homeowner could argue it's not, and then we're kind of rolling the dice on what the judge says. But the whole idea, and I think that ties into this policy statement that's built into the statute here at the bottom. But when we're having some of these discussions, the whole purpose of this is transparency and telling the board or telling the association and the membership what's going on. And when you have some of these gray questions or something that's kind of, in between, the Court of Appeals in the Sunland Springs case just kept coming back time and again to this policy statements, which I'll summarize and not read the whole thing because I care about you and it's boring. But the quick summation here is here in the bold at the bottom, but it says it's the policy of this state, whether it's meetings of the members association or meetings of the board of directors, whether it's an open or executive session, that they be conducted openly and that notices of the agenda be provided in advance for all information that's reasonably necessary to inform the members of the matters being discussed or decided and to ensure that the members have the ability to speak. That the board and the members of the board, as well as their community manager, shall take into account this declaration of policy and shall construe any provision in this section favoring open meetings. So the idea of this emergency spending, if you're delegating this authority to be done outside of this meeting, it's kind of going outside of it because you're saying, well, I'm going to give this authority to do something for an unknown dollar amounts. And it's kind of going against it. So use it sparingly and try to do everything in that open if you can.
So a couple other questions came in here, and one more of a comment, and I see where you're going with this. It says that everything in executive meetings is discussed in code in the open meeting. What's the value to the HOA membership? So why are we going through all this if we're just going to keep it secret?
Yeah. So, part of this is, so we have a piece of legislation that's pending this year that was already going to make these changes. And the reasoning behind that is that's how every public body is. So if you go to a city council meeting, this is how they already act. They discuss things in secret, vote in public. So the legislators wanted HOAs to match that. They want every vote done in public, just like any other public body would be. I don't know what the value is other than ensuring transparency and that while the members don't have all the details, they know for sure everything's being voted on in a meeting and they know exactly that everything their board is voting on is done at a meeting. So there's no, like John mentioned earlier, part of the case was the board had approved of a $900,000 contract at an executive meeting. Some of this seems silly, but I would argue that one is actually a pretty big problem, that the membership had no idea they were about to spend $1 million of their funds. So I think the value is they just want everything to be as transparent as possible. HOAs sort of get a bad reputation, in the media. So I guess the value is we can always argue, hey, we do everything in open meeting law and meetings, just attend the meeting if you're worried.
I like this question. It says, if the homeowner is present when the issue comes up from executive session, when you're taking the vote, can that homeowner speak to the motion?
So yes, they legally have a right to. You can give them a minute and just thank them and move on. I guess they're sort of outing themselves to the membership that that's what you're voting on, but nothing we can really do about that. But you do not have to give them very much time at all. For executive motions in an open session, I would argue 1 minute is completely reasonable. What can they possibly talk about for 5 minutes when they have no idea really what the motion's on?
And I apologize, I skipped one. What's the official start date for this?
2 Tuesdays ago when this came out, it was effective immediately to all of our surprise. Obviously that's not practical. It takes a little bit of a time to adjust. I don't know. I doubt any owner is waiting in the wings, ready to file a lawsuit on a board that had no idea this even happened until a week later. So I wouldn't worry too much about that as long as you're showing you're making moves to comply and changing procedures.
I'm taking note of all the requests for documents to share this PDF. So thank you everyone for putting that in the chat.
What's the timing of an announcement to all homeowners that these items have changed and how they've changed? You really, I guess you don't have to make an announcement to the membership by email blast or anything. You can just start sending out agendas that comply and doing this in a meeting, and or you can state at the beginning of your next open session that this is how it is now. But there's no requirement that you actually explain the law to them or anything. We have a study.
Yeah.
Oh, sorry.
I was just going to say, I mean, the timing of it is interesting because, as Kelly mentioned, there's already a bill pending in the legislature that we've been monitoring. Kelly and I are both on these legislative action committees and trying to tamp down some of the crazy bills that come through the legislature once in a while. So we're already aware that this was on the radar. And the way these typically work is that when a bill goes through the legislature, it passes both houses, it goes to the governor, and then once the governor signs off on that bill, it's effective 90 days later. So then we have this 3-month preparation period, this education period. We walk through it, with CADN and our boards, and everyone's kind of on the same page. This was different because it was an opinion from the Court of Appeals, and when it's from a court decision that's making case law, they're saying this is what it currently says and has always said. Even though a lot of these things aren't practical, right? Because a lot of things that you have for those 5 categories in your executive session, there's kind of already this rub. And the reason that we're going to, the CAD and account numbers to reference these things in the open session is because how can you talk about something keeping its confidentiality and privacy in an executive, but then still vote on it in an open? So there's kind of this dichotomy that you have to work through. So it was a bit of a surprise to have. So we're working through it. Great questions from everyone. If you guys have others, please feel free to throw it in the chat and answer any of those.
Yeah, I see one here. We have a study session which follows the board meeting. There's usually a quorum at the meeting, but no decisions are made. It's an opportunity for the board to discuss issues and have homeowner input. So that would fall under a workshop. And so if a quorum of the board is present, then yes, it needs to be noticed to the members. And also under the open meeting laws, as of last year, we now need to provide the agenda 48 hours in advance too. So you will need an agenda and notice. You don't need minutes if it's an informal workshop. It's probably a best practice to have them just for a record of what was discussed. You don't have to put a transcript, and I don't advise a transcript, but you could just, in the minutes, could be quorum of the board present, discussion of, I don't know, budget or maybe design guidelines, whatever you discussed at that workshop. And then it can be very simple, but just have a record of it for transparency's sake.
Oh, well, board members, I'm sure questions are going to come up as we navigate through this over the next few months, I'm sure. So as they come up, please reach out to your manager at any point, ask questions. If we don't have the answer, we will go find it for you as well. I'm sure Kelly and John would be happy to entertain a question as well. If you think of something right after this meeting, email us so that we can get back to you as well. I don't see any new questions in here. So Kelly, John, I want to thank you so much for taking the time out of your nights to meet with us and go through these changes. And board members, the same. Thankless position as we've talked about before, but let us thank you for volunteering for your communities and again taking your time out of your night on a non-board meeting night to join us to go over these changes.
It does look like we have one last question. What is the statute of limitations for alleging a violation? So generally, it will be about 6 years. We have discussed, so technically every HOA has been in violation since their inception because nobody's ever followed this law. The court has ruled that this has always been the law. So we have discussed, as attorneys and discussed it with each other, whether associations should go back and ratify previous decisions that were not done properly under this law. I do not think at this time that's necessary unless we see some other lawsuits going on that might change our mind. But as of right now, I don't think you have to worry too much about anything you've done in the past. Just change it going forward and show that you're complying. How many days notification is required for a work session? Any meeting, whether a workshop or executive session, open session, is 48 hours notice.
Getting those last minute questions then. Awesome. Jeff, thank you, and thank Cadden so much for giving us the opportunity to chat and kind of go over all of this. I know there's a lot. I'm hopeful that the PDF is helpful with everyone. But again, everyone at Cadden is a great professional, and they'll be able to answer all those questions for you guys. So look forward to working with everyone and getting that resolved. So thank you so much, Jeff.
Yeah, thanks for having us.
All right. Well, that said, good night, everybody. Thank you so much.